Gina Carano has settled her lawsuit against Disney, and people are losing their minds. They think that she sold out. Well, let's talk about exactly what happened. Welcome to Legally Sevvy, where we analyze the legal landscape of high-profile cases. On August 7th of 2025, Gina Carano, known for her role as Cara Dune in The Mandalorian, settled her wrongful termination and discrimination lawsuit against Disney and Lucasfilm. This case, rooted in Carano's 2021 firing over controversial social media posts, raises critical legal questions about freedom of speech, workplace discrimination, and corporate liability. In this analysis, we'll briefly examine the legal claims, key developments, the settlement, and its broader implications, including the role of freedom of speech in employment law. In February 2021, Lucasfilm, a Disney subsidiary, terminated Gina's employment following a series of social media posts on X. The most contentious post likened the treatment of conservatives in the U.S. to Jews under Nazi persecution, prompting widespread criticism.
Gina Carano will not be returning to The Mandalorian or the Star Wars galaxy amid backlash from a social media post the actress shared.
In a now deleted Instagram post, she compared being a Republican and a Donald Trump supporter to the experiences of Jewish people in Nazi Germany. That upset a lot of people, and the hashtag #FireGinaCarano started trending.
Other posts questioned COVID-19 mandates and included a pronoun-related comment, which many took fault to. Lucasfilms issued a statement deeming her post abhorrent and unacceptable, leading to her removal from The Mandalorian and the cancellation of a planned Star Wars spin-off, Rangers of the New Republic. Carano also lost representation from her agency, UTA. On February 6 of 2024, Gina filed a lawsuit in the Central District of California alleging wrongful termination, breach of contract, and discrimination under California's Fair Employment and Housing Act.
Carano filed a complaint on Tuesday in California federal court for discrimination and wrongful termination and alleges she was fired for voicing right-wing opinions on social media. Elon Musk, who made a promise to foot the legal bill for users who claim they have been discriminated against due to their activity on his platform, is helping fund the suit through X.
The complaint, funded by X Corp under Elon Musk's initiative to support freedom of speech, claimed that Disney targeted Gina for her conservative political beliefs, violating protections against discrimination based on political activities or affiliation. Gina alleged a double standard, noting that her male co-stars such as Pedro Pascal posted political content without repercussions. She sought at least $75,000 in compensatory damages, punitive damages, and reinstatement on The Mandalorian, citing verbal assurances from director Jon Favreau about future projects as evidence of an implied contract. X Corp's financial backing, driven by Elon Musk's commitment to defending users penalized for online speech, elevated this case profile. Gina's legal team argued that Disney's actions constituted discriminatory retaliation. A pivotal development occurred in April of 2025 when the U.S. District Court judge granted Gina's motion to compel Disney to produce compensation records for The Mandalorian and other Star Wars projects, bolstering her claims for lost earnings.
Gina Carano gets a massive win against Disney. Gina Carano wins big against Disney in lawsuit discovery battle. Judge orders Disney to hand over actor pay records within 20 days.
The ruling signaled potential vulnerabilities in Disney's defense, particularly regarding the financial transparency. Disney also had to produce records as it related to male co-stars and what they did to curtail their freedom of speech in Twitter or X, which we know they did not. On August 7th of 2025, the parties announced a settlement filed with a stipulation to dismiss the case with prejudice, meaning it cannot be refiled. The terms, of course, remain confidential, precluding disclosure of any financial award or specific conditions. Notably, Lucasfilm issued a statement on X praising Gina Carano as well respected by her colleagues and expressing openness to future collaborations. That's a significant departure from her 2021 stance. Gina Carano's ex post acknowledged the settlement as a mutual resolution and thanked Elon Musk and her legal team, while expressing hope for healing in the industry. Now, people have been freaking out because they say she gave up. They say that if she didn't take this case to trial, she really didn't mean to fight for freedom of speech, but she has. This case underscores the critical role of freedom of speech in employment law. The First Amendment protects individuals from government censorship, but private employers like Disney can impose some workplace consequences for speech that is deemed harmful to their brand. Under California's law, however, employees are protected from discrimination based on their political beliefs or activities, provided they do not disrupt job performance. Gina's lawsuit tested this framework, alleging her termination was discriminatory rather than performance-based. Freedom of speech is fundamental to democratic societies, fostering open debate and protecting minority views, even when they are controversial. In the employment context, it ensures that workers can express personal beliefs without fear of retaliation, provided that they meet workplace standards. Gina's case highlights the tension between corporate discretion and statutory protections, raising the question about how far employers can go in policing off-duty speech. So let's analyze the settlement's implication. Gina's confidential agreement likely includes financial compensation. It potentially addresses her demand in her complaint for $75,000 and lost income from the Mandalorian and related projects. Lucasfilm's conciliatory statement may mitigate her industry blacklisting. Her return to Star Wars is up in the air and is probably very unlikely. For Disney and Lucasfilm, the settlement avoids a costly trial and public disclosure of internal records, particularly after their $15 million settlement with President Trump in December of 2024. This case also exposes Disney to scrutiny over alleged inconsistent treatment of employees' political speech, a point that Gina's team leveraged effectively. So, for employment law, this settlement signals potential risk for corporations who discipline employees for what they say in social media activity. We all heard, well, I don't know if you heard, but there was a case where Meta, Facebook, contacted an individual's employer. Yes, this is the AI. This is not Facebook. This is not one person. Their AI contacted his employer to let him know what his stance was on COVID-19. And this didn't happen in 2021, 22, 2023. No, it happened this year in 2025. California's employment statutes and other similar statutes in other states protect political expression. Gina's case, even though it did settle, it will embolden other employees who are fired or disciplined for political speech to take arms on it and fight it instead of giving up and letting that happen. Moreover, this settlement also reflects a broader trend of studios navigating polarized cultural landscapes, as seen in Disney's recent adjustments to diversity policies, which probably did happen because of the executive order against illegal DEI, but it's still a shift. Courts may increasingly scrutinize whether terminations based on speech violate anti-discrimination laws, particularly when the policies are applied unevenly, such as in this case. The Gina Carano and Disney settlement illustrates the complex interplay between freedom of speech, corporate law, and employment law. While the settlement terms remain confidential, we really don't know if there are terms that restrict Disney in how they treat other employees, not just Gina. As employment law continues to evolve, because it evolves every day, this case will influence how employers balance brand management with employees' rights. What are your thoughts on the settlement legal implications? Should employers have broad discretion over employees' freedom of speech? Or will statutory protections such as California's employment law go far enough? Do you agree with Gina? Do you agree that she should have settled? Or do you think that she should have taken this case all the way to trial? Please share reviews in the comments below and subscribe for more legal analysis. Thank you so much for watching, and I will talk to all of you later.